Hi, good afternoon, Yinka, and welcome to today's session, which is, starting a new unit, which is employment legislation. Um, I'm just about, was about to send you an email, but it's good that you've been able to join. So I'm going to try and, discuss the first learning objective of the unit here, which is to understand the key concepts in employment law in a particular country. And here I put together a few slides which will cover learning outcome 1 and the two assessment criteria, 1.1 and 1.2. So let's dive straight into these slides. And if you have any questions, please feel free to ask me through the chat room, or stop me, and I can try my best to answer some of the queries. So the aim of this unit, first of all, let's look at this unit. Now, what we're looking at is primarily when you look at studying this unit, we are looking at this thing. If I just go back slightly and look at, how we have covered the journey so far in terms of HRM. Now, when we look at, we started off with, basic things like studying and understanding human resources management. We looked at, at some stage, getting into the second unit, which primarily looked at basically understanding the theoretical framework, the various models of it. Then we went into something which was related to contemporary issues in HRM, or the issues which are on the way. And after that, we went into something in terms of a unit to understand let's put it this way, leadership and the concept of leadership management, and how it is important to marry the strategic intent of human resources management and marry it with the aims and objectives of the organizational objective, or the objective set in terms of vision and mission for the company. After that, we looked at understanding how recruitment. In the first unit, we understood recruitment, selection, training and development, and the key function of HRM. But we looked at specifically one of the functions of talent management, or retaining talent when you work within a global organization. So from that context, we understood things like what is global talent management. We looked at understanding some of the challenges which HR managers, modern day HR managers actually face in terms of managing talent. When we look at managing people across various geographies, various divisions, various departments, and what were the barriers in managing this particular process of keeping employees happy within their roles and motivated enough to be able to achieve and strive to achieve the organizational objective. Towards the end, what we look at in Unit 6 was understand, a new concept of performance and reward management. Now, performance management cycle, techniques were always a part of HRM, but as the sector has changed and evolved over the years and the decades, what we wanted to do was specifically look at understanding, what is meant by performance, what is performance management, and how this performance management relates to reward management and reward management strategy within the organization. We briefly looked at some of the performance management systems, the models, the PMT, which is performance management, PMC, which is performance management cycle, and then today we are looking at getting into the next stage of understanding the next shift, which is to look at understanding employment related law, legislation. We're looking at understanding domestic, regional, international treaties, what kind of law and legislation the HR department and the HR manager, modern day HR manager, has to be aware of and they have to follow. And to a certain extent, it relates to what we're looking at covering in this particular unit will be the the key principles that kind of underpin the employment law in a particular country. So here we have to look at things like rules, regulations, the directive, and how as an HR manager you on a case-to-case basis is able to deploy them and use them within the organization. And we'll towards the end we'll also look at in learning outcome 1 would be look at types of contracts which are definition of employees, and certain things which are part and parcel of when you look at employment legislation, things like implied terms, express terms. Some of these terms we will borrow from the legal system, because when you put together employment contract, you need to be aware of rules and legislation or regulation in a particular country which needs to be applied so that the contracts which are given out, conform to the statutory guidelines and legislation in a particular country in terms of labor laws and other things that we will discuss in this particular unit. Let's get into understanding the the reason why employment legislation is required. So I've put together a few questions on a few slides, and the idea of having these questions on the slides is primarily to understand why employment law is needed, why there is a legislation which is required when you employ people or when you have staff working for you within the organization. So the first question that we look at is, why does employment law exist? Now here, the employment law exists because we want to look at some clear directives or clear guidelines to which employers and employees would conform, and this would allow the whole process of people working within the organization to work effectively. So if I just go by the definition, here we are looking at is that employment law exists because we need to comply with legislation in a particular country. When you hire people, you employ people, when you have staff, members of public employed as staff in a business or an organization, you need to be able to conform to some processes, whether it's during the process of recruitment, whether it's in the process of dismissal or exit from an organization, and in general, the whole the concept of HR. When we looked at the HR planning process, when we look at you recruit, you select, you train, you develop, you look at labor laws, and then you look at contracts and things like that. So the whole essence of having a contract is in place to primarily ensure that the hiring processes and the dismissal processes in a particular workplace, in a particular country, are fair and are quite fair and just as far as individual and the organizations are concerned. So it helps us combat discrimination. It helps us combat and promote equality at work. Now, why do we need? So the first, why do they exist? Now, the lead-on question to this is, why do we need legislation? Now, because when we look at laws and when we look at acts or information which are converted into laws passed by the Parliament or a statutory body within a country, we do see employment laws are put in place because they need to be able to protect workers and employers, on both sides, and there is a dual responsibility. So the employer needs to employ people fairly, give them fair, compensation, and expect, and the employees on the other hand can actually expect, safe working conditions and also no, discrimination when they work for the employer and try and achieve the objective. So here, when we look at, what we are trying to do is the employment law is actually going, because it's put in place, is actually going to protect workers from wrongdoings or unfair advantage which the employers can get. And the other thing would be that some of the statutes that we look at also eliminate some threats which are related to employment. Now, these could be, for example, when we look at companies sometimes employ individuals, if there's a minimum wage act, say for example in the UK, the minimum wage is defined for people under 20, under 24, and anybody below the age of 24, the minimum wage is £8.50 per hour. Now, employers have to comply with this legislation or this law, and when they employ people, they have to minimum pay. They have to pay the minimum wage to persons being employed and working within a role. So this does away with the fact that the employees cannot unduly take advantage of a person to employ them at a salary which is not meeting the minimum wage requirements in the UK. But at the same time, if the employer works, if the employee works within the employment sector or within an organization, they have to also get certain other statutory benefits, which could be things like pension, which could be things like a clean and safe working environment, and generally the workplace or the premises need to comply with health and safety laws, and the compensation has to be in line with what has been drawn out in the contract. So if we look at a simple answer to employment legislation, why are laws required? Because they protect workers and employers, or employees and employers both, because law tends to create a safe working environment which is consisting of policies and principles, and these apply to both employees and employers, and it helps them take use of the laws to be able to protect them from doing wrong, because the law ensures that there is a compliance when people start working within the organization. Now, let's look at the meaning of legislation. What is employment legislation? We know legislation in general, when we look at, it has various meanings. But here, the context of legislation that we want to look at, in particular, is to understand what is employment legislation. So, say for example, if I use the word legislation, legislation means nothing but law in the literal sense. That means you have to collectively look at certain things which have been defined, and these things when are defined, govern employment related policies and procedures in a particular organization or at a workplace. So when you look at employment legislation, this is basically law, and it is governed by certain principles or statutory laws within the country, and it binds the workplace and everyone working within the work to obey the rules and regulation which are related to employment aspect. Now, what does this actually imply? It implies that it creates equality in workplace. It implies that it creates fairness, and here the purpose of employees is to make sure there is some requisite condition which is available, so that the people are able to work free without any discrimination. They feel confident that there is equality, and there is no differentiation among working within particular organization, and that is where it is used to establish working conditions and to do away with things like discrimination, harassment, sexual discrimination. Some contemporary issues that we looked at, when we studied Unit 4, we talked about issues like discrimination, sexual harassment, pay gender gap between males and females. We looked at conditions to do with working conditions, health and safety. Now these are things which were contemporary issues, but these issues are governed under the employment law, and we look at some of the acts which are relevant when we study employment legislation within the UK context, and I'm going to cover that in the next few slides. But in general, here it establishes working conditions, some sort of a boundary through which companies, or let's put it this way, employers and employees interact and operate, which is to ensure that they have safe working conditions, and there is no discrimination or unfair usage of employees or resources or things like that. Now, what are the main features of employment legislation? Now, there are lots of features of employment legislation when we look at specifically in the context of UK. Now, employment legislation looks at minimum wage. It looks at whether you're part-time, full-time employed. It looks at discrimination, health and safety, holiday entitlement, pensions. It looks at perks and benefits, redundancy pay. It looks at dismissals. It has things like disciplinary procedure, and obviously training and development, and last but not least union rights. So when we look at in particular the legislation in the, what we actually looking at is there are lots of features of employment legislation in the UK, but they are the as I say, minimum wage. If I just separate them out, hours worked, discrimination, health and safety, holiday entitlement, how is it calculated, redundancy pay and dismissals, disciplinary procedures, training and development, and obviously union rights. So these are when I say what is the remit or the boundary of employment legislation, this is what I will say will be the boundary within the UK context. Now, if I do the details, what we're looking at understand very briefly how this works across to be able to do a bit of comparison. Now, so what we are looking at is in country, whether it's federal, state, or local laws. When you look at the US, we look at Canada, we look at UK. When you look at federal laws, you look at state laws. If there are lots of states, like in England, in the UK, you have England, Wales, Scotland, and Northern Ireland. These are all independent countries, and we are under a union, which is Great Britain. But when you look at a large country like United States, they have lots of states, and there are federal or state laws and even local laws that influence workplace rights and workplace conditions. So it is important for us to understand and be able to differentiate how employers follow and interpret this law. in such a way that it is showing responsibility, but also is able to the implementation of this law is also harmonious to the workplace. That means it is conducive to a particular place. Now, we also look at sometimes why do we have laws? Because laws actually, why does the government create laws? Let's look at this aspect. The laws created by government kind of guarantee rights. These could be rights for employers, these could be rights for workers, and these kind of rights which are guaranteed by legislation or law are done in order to protect employees and employers from taking unfair advantage. So when we look at what kind of rights does that guarantee, when we look at legislation, there are broad types. We look at hours that you work and you're employed on an hourly basis. Do you get overtime pay? Or when you work beyond your hours which you're contracted for, then you're supposed to get overtime pay. What is the minimum wage? When do you get paid? In the place that you work, for example, if you work within a factory, if you work within a production service facility, you work in a construction site, if you work within an office, or do you have a safe working environment which is conforming with health and safety laws of the location? How is your holiday pay calculated? How many holidays do you get? In compliance with public holidays, wherein it's a holiday for everyone, whether you work in private or public sector. What kind of breaks do you get? Specifically, when you look at contemporary issues or some laws conform to now paternity leave, but earlier it used to be called the maternity leave, pregnancy leave. How does that particularly comply with, and what are the laws around that? And last but not the least, if you are to be, if you're made redundant, what is the procedure which the employee needs to follow to be able to ensure that you are made redundant in a fair and just way? If you have been working in an organization for a number of years, then you are due to get redundancy pay, and then due notice in terms of notice period has to be given when your employment is being terminated. If you have been asked to, if the employer has to terminate the employment abruptly, then they are liable to pay you termination pay. Let's put this into a bit of context and understand how it works in the case of some places or countries. So when we look at in the US, there are different acts which have been created over the years, and obviously when we look at how they protect rights, employers' rights, what we do see is that in the US, Fair Labor Standard Act, maximum wage, or overtime pay, record keeping, and be looking at employment standards which the companies have to provide to people with nations. The eventually is another organization under the government which which basically prohibits discrimination against job applicants and employees of federal contractors. That means people within contracts or under subcontractors get the same type of have the same employment applied. When it comes to obviously their pay, perks, benefits, and other related compensation. If we just look at Canada, in Canada, most workers, about 90% of them who work are protected by employment law, which is in the province or the territory. So Canada also has states, but these provinces have their own laws. So obviously, most of the worker rights are protected by employment laws, which are created by the province or the territory. So when you look at Manitoba, you look at Vancouver, you look at Ottawa, those provinces, Alberta, and they have their own laws which cover, employment rights. And these laws include hours of work, overtime pay, other things which relate to employment contracts, related to working conditions, and also health and safety. Now, a simple application of this, if I have to explain with an example, what are the main narrowing down, because there are lots of different laws. So narrowing down employment law. The minimum wage, is a law in Canada wherein the minimum wage that there is a basic minimum wage which the employer has to pay to every employee working, in Canada. Now, the minimum wage, legislation in Canada was introduced, maybe in what you call in early, early 80s. The current minimum wage, if I look at, as per last year's, is that the minimum wage which is applicable depending on the province in which you work, varies between $11.35 to about $14.60, per hour. And that is the minimum wage that we look at, applicable in, in the country Canada. So here the employees must be paid at regular intervals, and they are given statements or some sort of a salary or wage slip to show what is being deducted. Sorry. And at the same time, they need to be paid at regular intervals to be able to, draw those benefits out for which they are providing services to employers. And most workers within Canada, when they are employed in contracts, they have the right to get annual vacation with pay. That means it's paid leave that they get when they apply for across the calendar year annual vacation. Now, if I have to understand quickly the background, when we look at how it all started off in the UK, there are a few slides that are put together which are basically for background information. And here we look at the Employee Governance Act with some sort of an approach put together in the early 1800s. That was called the Combination Act. This act was then changed and abolished to become the Act of Employment in the early 1800s, and became a Master and Service Act agreement. And it was later further changed in the 1860s to become a Trade Union Act. And then in the mid 1960s, after the World War II, this act was replaced by the Donovan, based on the recommendations of the Donovan report in the UK. This was changed to, come out. This in particular legislation was spread out, and a lot of different laws and acts were created, which catered to, different types of employment opportunities which were generated. Because when the industrialization started to happen, when we look at the industrialization, a lot of people started to work in factories, production sites, engineering sites, and large-scale development started to happen. There was a need for a lot of different types of provisions to be created, which meant that each and every, legislation, each and every, requirement of employer and employee legislation, or requirement was actually met. And this was then put into some sort of a legislation which led to the creation of these acts. So in the early 1970s, a lot of statutes which came out of this common law actually became employment laws or employment law statutes. So when we see the journey, the Qualification Act led into Master and Servant Act, led to the Trade Union Act. But in the early 1960s and 70s, this was broken down into something called the three main sources of employment law, and they became the common law, the statute, and obviously the European law. Now, under the employment law, we look at lots of acts, and these acts, I've listed them down here. They were the Equal Pay Act of 1970, Health and Safety Act at Work of 1974, the Sexual Discrimination Act of 1975. The Trade Union and Labor Relations Act of 1992, Disability Discrimination Act, Employment Right Act, Data Protection Act, Human Rights Act. Then we had Employment Relation, National Minimum Wage Act, and then also Disability Discrimination Act, which was updated in 2005. So some of these acts over the years have been updated by successive governments, and they have and track with the changes which are happening in labor workforce market, and these acts have amendments. So when we look at the Health and Safety Act, which was introduced just as an example in the early 1974 or in the year 1974, it has undergone a lot of changes, and all these amendments to the act have been done in order to conform with the modern day guidelines of health and safety when we look at working within an organization, an office, a factory, construction sites, and things like that. Now, another example I would give you here would be when we look at the Data Protection Act of 1998 in the UK. This was raised by a pan-European Journal Data Protection Regulation Act, which is called the GDPR, introduced in 2015, and all companies had to comply last year by 25th of May, and that means data the companies collect, how they collect, how long they keep, and how is it regulated, and who has the access to data is all governed under the GDPR Act. Now, in order to understand how this is all related to the implementation of HR policies in the organization, we have to understand, the basic definitions of who's an employee, who's an employer, and what kind of a contract entails between an employee and an employer. So when we look at, understanding all these employment laws, these laws are all enacted either in favor of the employee or, when I say they are used when employment is created. So we need to understand the concept of employment, then enact these laws. And in order to enact these laws, we need to be able to look at understanding the two sides to which the law actually applies. One is the employer and the other is employee. So let's look at who is an employee. Now, under the Employment Rights Act of 1996, it is defined that employee is an individual who's entered into some sort of a work or a contract of employment. And the employment here is defined as, the nature of services which the person, either expressed or employees, will be providing to the employer. So that constitutes the definition of somebody who is going to be. Now, in some cases, this was challenged. Or, sometimes when you have laws, they are challenged in court when we have, they're not working or serving the right purpose, and that leads to the creation of amendments. And these amendments then, are kind of quoted as cases which are brought against to bring these amendments or pass these amendments, as far as the laws are concerned. So one of the amendments to this law happened when a case was brought in by Catamaran Cruisers versus Williams, and it was held that the individual can qualify as an employee even if the service provided was through a limited company. Now, to explain this example, what happens is the government into the concept of zero-hour contracts. So here what tends to happen is that employers sometimes do not employ individuals, but they keep them on probation because or keep them and work with them as contractors. So what they try and avoid here is they try and save on the basic remuneration that they have to include in the packages when they employ people. Things like your basic salary, but some part of that salary will be provided as pension. You'll have some other additional benefits like you accumulate holiday pay, and you at the end of the year you'll be also entitled to, if you're working as a full-time employee, you're entitled to a sort of a redundancy pay should the organization go into administration, or should the organization cease to trade or do business. So over the years there was amendments being brought out, and what tended to happen was that the employers found a loophole that they could employ somebody for 12 weeks and then fire that employee so that they never became part of the organization, and that means that they were never supposed to get the full benefits that the employee normally gets from an organization when they are full-time employed. So they found a way around it, and what they said is that if you work with an organization, the government introduced a legislation saying that if you employ somebody for 12 weeks, you have to offer that person employment. Now, the employers got around this legislation by saying that if you work for 12 weeks and then we have to fire you, again hire you, that process is now denied by the government. So what you have to do is you work through a limited company, you open a company rather than working directly, you open a limited company and do work through that limited company. So company to company, they could hire a company for services on a consultancy basis. Once the services are finished, they could kind of close that contract and introduce a new contract. That meant, again, the employees were not getting the pension or other benefits which they would get, but the same person was continuing to work with the organization to offer services. So the case versus Catamaran Cruisers and Williams highlighted that as a problem, and because of which there was an amendment which was brought out by the government in the Employment Act of 1996. Now, similarly, with acts related to discrimination, this was an act which was introduced in 1976, and this meant that when you do recruitment, you're not going to be discriminative, basis the race, the sex, marital status, and ethnicity of the individual. Now, discrimination occurs. When do you think discrimination occurs? Discrimination occurs when a person is treated less favorably on the grounds of, on the grounds of sex, marital status, racial background, and or the background that they come from. Now, if you feel that this has been done and you have been treated less favorably, then this amounts to, discrimination. So again, a case was brought out in the case of Shamoon and, Chief Constable of Royal Ulster Constabulary, and here a complaint was made by the traffic branch about the manner in which the Chief Inspector Shamom conducted appraisals. So the case, basically went to the court, and obviously, right to carry out appraisals was taken away from, and then Shamom claimed on discriminative grounds, which meant that, the judge took a decision that, because he was from the Asian background and he was responsible for appraisals of a lot of employees, in the constabulary, whether it's native English or, Asian or different origins, that right of being taken away amounted to discrimination. So when he won the case, obviously this was acted on as an amendment, and this is, treated as amendment to this Discrimination Act of 1976. We look, some of the other acts, and I've put together a few slides here which you can go through, and they are in the context of, UK or United Kingdom as a territory. Now, of laws which have also been introduced, which are called remedies to discrimination. So when we look at the Discrimination Act in particular, we see that discrimination can happen on the basis of religion, caste, or your background. Sexual discrimination is a separate act, and if this happens, this is an act under Sexual Discrimination Act of 1975. And here, when employers kind of recruit people or are recruiting people, and they make a statement in the job application or the job advert saying that we would prefer to have a female in this position, we would prefer to have a woman between the age of 25 and 35. This amounts to discrimination on the basis of sex. That means you are not going to be favoring or taking interviews or looking at less favorably male employees who apply for a receptionist role. So this would mean that the person has been treated unfairly because they have, in the job application or the job advert itself, they've specified that for the position of a receptionist, the organization is actually looking at preferably hiring women rather than men, and that would amount to sexual discrimination. As HR managers, we need to be able to do is understand the employment legislation, apply these acts when some of these things are being put out, as adverts by the employers. So sometimes the compliance can only happen if you have knowledge about these acts and knowledge about the legislation and how to apply this legislation in the case of, the job advert or recruitment advert for a receptionist in the organization. Now, very briefly talking about, things like when we look at, these acts which have been created, like we look at the Employment Rights Act of 1996. Here, it basically states that employees cannot be unfairly dismissed. That means if you feel that you've been unfairly dismissed from the organization because of XYZ reason, you can take your matter to the unions or the court here, and under this particular act, the law would make sure that, or basically provide you a remedy wherein you have the right to appeal, and you can put your evidence forward. If you are, obviously correct in that interpretation, then, you can challenge the employer, and obviously the employer will have to re-engage with you in terms of employment. So when we look at, some of the legality of application of these laws, what we do get to see is that if you have had an unfair dismissal, in this case, the remedies which the law also provides for you to be able to go back and make this inquiry and put this right would be things like, in the case of unfair dismissals, specifically reinstatement, the employer has to re-engage with you to solve a dispute, or reasonably look at a favorable position which can be reallocated to you. In that case, if they're not able to do that, then they have to offer you compensation. So all these acts that we look at and the legislations that we look at are primarily created to basically protect workers and workers' right, and also the employers, so that they are able to apply this legislation fairly and unjustly when they try and employ workers within the business organization. Let's look at, after going through this, so let's look at drawing some sort of a conclusion. The first learning outcome basically talks about we need to understand the key concepts of an employment law in a particular country. Now, from a UK context, and given you some broad idea about the laws in US and Canada, what we want to be able to do is understand that we clearly now know, after going through a few slides, that what are the aims and objective of the employment legislation. The second bit is to understand what is the role of contract in employment. And when we apply these, and how to apply these contracts in employment is explained by, the employment laws within a particular country. So I hope, today's session clarity in terms of learning outcome. What I'm going to do is send across a bit of a handout which is specifically related to, the UK side of law. And here, when I say because what I want you to be able to do is understand at least, from a point of view of this unit that we're going to be covering, that you need to have a good understanding of the employment laws and legislation within a particular country. So I've got two handouts in particular. One that I'm going to be, obviously sharing with you on the email. And this particular handout focuses on just very briefly showing you, on the fact that it will give you the full UK employment guide, which an HR manager normally goes through when or has, tailored to the requirements of a particular organization when they apply these laws and legislation with regards to employment contracts and, worker rights and other things related to employment in the organization. This is an extensive document, about 50 odd pages, but I expect you to basically go through some of the key pages in terms of, understanding how, what is the key legislation, some of the key aspects given across, on I'll show you very briefly, quickly. So here, this is a particular, a good handbook, primarily just coming back to what I want you to focus on. To understand what is the guide to UK, and if you think it will pretty much cover the full unit, and I'm going to be, slides that I put together are also adapted from this particular, handout. The idea would be to read some of this stuff, which is primarily the types of laws, because we need to be able to understand this from a particular country context, and we need to over the years, and they are the ones which basically create legislation, and the employers have to follow this legislation or code of practice to be able to look at employment and other related services within employment legislation. So both the present and the handout are available on Moodle as well, and I hope to be able to look at understanding which is going to be talking about recruitment and selection, in terms of legislation for a particular country, and we'll focus on UK and some part of the the things which I'm going to bring out in terms of principles of legislation and mechanisms of contracts currently would be coming in UK employment guide. If you have any questions, drop an email and I will come back to you as soon as. But apart from that, I'm going to try and end this session here, and I will catch up with you tomorrow to cover learning outcome 2. Thanks for joining, and bye for now.